Hello friends, in the series on income tax cases, today we will discuss an issue in which the assessing officer issues the notice to the assessee under section 148 to complete the assessment under section 147, and already in the case of the assessee, the assessment under section 143 subsection 3 has already been completed, or assessment under section 147 read with section 143 subsection 3 is already completed. If the notices are issued in such type of cases, then according to the proviso to section 147, there is one additional jurisdictional requirement that it should be proved by the assessing officer that the assessee was aware of some information and then he suppressed that material at the time of filing of the returns. If this jurisdictional requirement is not met with, then the notice under section 148 cannot be issued for the same year. This issue has been taken by the Bombay High Court in the case of Sociedade, Fomento Industrial Private Limited versus Assistant Commissioner of Income Tax, and this case has been reported in 464 ITR at page number 261, and the matter has been decided by Bombay High Court, and the date of the judgment is 19th January 2024. In the present case, the assessment of the assessee for the assessment year 2008-9 was already completed, and again the notice under section 148 was issued to the assessee on 20th October 2014, and it was very clear from the facts that this notice has been issued beyond a period of 4 years, so the proviso to section 147 is applicable. The basis for issuing the notice was third Shah Commission report and information from the Director of Intelligence Mumbai. The assessing officer copy and pasted some portion of the third Shah Commission report and issued the notice to the assessee without establishing the live link between that information and the income escaping assessment alleged in that notice. It was only the reproduction of that report, and the assessing officer has grossly failed to establish that how that information can entitle him to make the reason that the income has escaped assessment. Moreover, it was the submission of the assessee that the third Shah Commission report has been prepared on the basis of the Supreme Court judgment in 2014, and in that Supreme Court judgment, the Supreme Court had said that the lease mining business in Goa and whatever the leases have been given in Goa after 22nd November 2007 were illegal. It was the point of the assessee that when the Supreme Court judgment came in 2014, this judgment was not available either with the assessee or with the assessing officer when the time for filing the return for that assessment was there with the assessee. So, how the assessee can give that information to the department even if the assessee do not have that information, and that information has come after a long period of time. When this matter was heard by the Bombay High Court, the Bombay High Court said that in the present case, the court has the power to determine whether the assessing officer has the information and whether on that information the assessing officer can make his reasons to believe that the income has escaped assessment. So in the present case, since the assessing officer has grossly failed to establish that the assessee has to give some information to the assessing officer at the time of the original assessment, so it is a jurisdictional defect and the notice issued by the assessing officer is null and void. So the Bombay High Court quashed the notice. At the end of this video, once again I am repeating the name of the case. The name of the case is Sociedade, Fomento Industrial Private Limited versus Assistant Commissioner of Income Tax and others, and this case has been reported in 464 ITR at page number 261, and the matter has been decided by Bombay High Court, and the date of the judgment is 19th January 2024.